Wushuwunoag ni Tampag. Haskatasquamson. How are you all doing, family? Neesu Wushuwunoag, Director General of the Federation of Aboriginal Nations of the Americas. Hoping that this evening or day, perhaps where you're at and you're watching this, many thanks to those who watch these videos from the many different places that you do. We are very honored and humbled that you find this information of interest and benefit. But just hoping that during these very turbulent times, that you're first of all taking care of yourself, mentally, spiritually, and physically. And that you're aware of kind of what's going on around. In particular, wanted to have a discussion tonight that in many ways relates to the circumstances that took place on January 6th at the U.S. Capitol, but relate to an ongoing conversation that has been being had and that we've been having just around black identity extremists and, not properly moving in law but making legal claims and what type of response that could get. And that's because this terminology of domestic terrorism is starting to be popularized. And it's something that you should be aware of. So the conversation I want to have with you all tonight, and you all, as always, double check this stuff yourself. Make sure that the information that's being shared is appropriate and factual and truthful from any source that you hear from, not just from us, from anyone. Check this out yourself, because there's a lot of conversation in different circles, so we've been hearing, about the terminology of expatriation, and you often hear nationality and all of these terms, and we want to make sure that everyone has a clear understanding of what these terms mean, particularly in U.S. law, and understand that there's actual processes that you're supposed to go through to do certain things. It's not just declarations and filings. There's processes. So let's first look at the term nationality. And what is nationality? And this is coming out of Black's Law Dictionary, edition 2. That's the free one you can get access to on the internet. And nationality is defined as that quality or character which arises from the fact of a person's belonging to a nation or state. That quality or character which arises from the fact of a person's belonging to a nation or state. Now, nationality determines one's political status. However, domicile, and that's another term, determines one's civil status. So nationality is political status. Domicile is civil status. So political and civil status are different concepts. Political is going to be a different body politic, a different nation, something separate from the U.S. Civil is going to be what's under the U.S. And that's important to understand, because when you look at federal Indian law, American Indian is considered to be a political status, not a race or an ethnicity, a political status. So it doesn't matter if you're black, white, whatever. Separately, you are an Indian in a separate political status. However, that's tied to your nationality. Your nationality. Your political status is tied to your nationality. And remember, political status is separate from civil status. So now let's look at the next. I'm sorry. And it arises, a nationality arises by birth or by naturalization. So you can be a national, have the nationality of a place, a nation, by birth or by naturalization. So you either have to be born there or you have to be naturalized there, born somewhere else but naturalized over. Now let's look at the term citizenship. And citizenship, once again in Black's law, is defined as the status of being a citizen. And of course, if we're going to look at the definition of citizenship, we then have to look at the definition of citizen. It says a member of a free or juror society. A citizen possesses rights and privileges under the Constitution, but they're subject to the accompanying duties. So citizenship is to be a member of. It doesn't necessarily have to do with birth or naturalization. It means to be a member of a free and juror society and to possess rights under its constitution, but to also be subject to its duties. So if you're going to enjoy the rights, then you also have to be subject to the duties associated with access to those rights. So paying your taxes, obeying the laws, whatever the case may be, whatever that particular society has decided under its constitution. The point I'm pointing out here is that nationality and citizenship are two different things. And nationality arises by birth or naturalization. Birth or naturalization. So you, right now at this moment, if you have a birth certificate, if you got one of those, if your parents got you a birth certificate, you are considered a national, at the very least, of the U.S. You're a national of the U.S. Additionally, because you have rights to privileges under the U.S., so if you have a social security number, health care, if you got a job, if you opened a business, whatever you did that was a privilege underneath U.S. law, you are considered a citizen of it, and you are subject to the duties along with it. So your nationality is because you were born in the U.S., state birth certificate. Citizenship is social security number, anything that's U.S. created that you utilized or that your parents utilized for you. So you're a national and a citizen. Now, how do we know this? How do we know that that applies to you? Well, we can look at some U.S. code here. And this is a very important code to look at. This is 8 U.S. Code 1401. And in particular, we're looking at B. 8 U.S.C. A little chilly down here. 8 U.S.C. 1401, in particular B. And 8 U.S.C. 1401 is nationals and citizens of United States at birth. Nationals and citizens of the United States at birth. And the language goes to say, the following shall be nationals and citizens of the United States at birth. So if you have a birth certificate under 8 U.S.C. Code 1401, you are both a national and a citizen of the United States. A says a person born in the United States and subject to the jurisdiction thereof. Now, a lot of this conversation pops up, I'm indigenous, or I'm an Indian, I'm an Aboriginal, you know, I'm autochthonous, I'm all of these terms, right? But let's look at what B says. Let's look at what B says. A person born in the United States. Now, the following shall be nationals and citizens of the United States at birth. A person born in the United States to a member of an Indian, Eskimo, Aleutian, or other Aboriginal tribe. A Indian, Eskimo, Aleutian, or other Aboriginal tribe. So even if you're claiming to be autochthonous, indigenous, original, you're still a national and a citizen of the U.S. if you have a birth certificate. If you've got one from the state when you were born, you are a U.S. national and citizen. Now, this is the interesting part, and this is where the enrollment or citizenship in a tribe is important. And then it comes down to what the status of the tribe is. Because you can't just simply say, I'm not a member of the U.S. anymore. I'm not a citizen of the U.S. You can't just say, well, I expatriated. You can't just go file something on the county registry of deeds. That's not how the U.S. process works. So just because you're saying that's what you did, and just because you filed a few things, that doesn't mean that's actually what you are. You still are a national and a citizen of the U.S. if you have a state birth certificate, unless you have gone through a process of renunciation. Renunciation, the actual process of renunciation or expatriation. So what is renunciation? Once again, Black's Law. This is the act of giving up a right. Now, what is this right that you're giving up? Well, those rights would be all of the things that you have under the U.S. Constitution. So when you renunciate your U.S. citizenship and nationality, you're saying I have nothing to do with the U.S. anymore, its Constitution or anything. And in order to do that, and you can find this rate on the departmentofstate.gov, travel.state.gov, says renunciation of U.S. nationality abroad. The Immigration and Nationality Act, Section 349A5 of the Immigration and Nationality Act, INA, 8 U.S.C. So 8 U.S.C. 8 U.S.C. 1481A5 is the section of law governing the right of a United States citizen to renounce abroad his or her citizenship. This section of law provides for the loss of nationality by voluntarily with the intention of relinquishing nationality. And here are the elements of renunciation. Appear in person before a U.S. consular or diplomatic officer. So have you appeared in person before a U.S. consular or diplomatic officer to renounce your U.S. citizenship and nationality? No? Then you're still a U.S. citizen. 2, in a foreign country at a U.S. embassy or consulate, and, so one of those two, and sign an oath of renunciation. Have you signed an oath of renunciation with the U.S.? No? Then you're still a U.S. national and citizen. Renunciations that do not meet the conditions described above have no legal effect. Because of the provisions of Section 349A5, U.S. citizens can only renounce their citizenship in person, and therefore cannot do so by mail, electronically, or through agents. In fact, U.S. courts have held certain attempts to renounce U.S. citizenship to be ineffective on a variety of grounds, as discussed below. And I'm not going to go into those, but you can look that up as well. Now, I want to go down to a certain particular element, and this is what we've been saying for a while now. D, dual nationality / statelessness. Persons intending to renounce U.S. citizenship should be aware that, unless they already possess a foreign nationality, they may be rendered stateless and thus lack the protection of any government. They may also have difficulty traveling as they may not be entitled to a passport from any country. Statelessness can present severe hardships. The ability to own or rent property, work, marry, receive medical or other benefits, and attend school can be affected. Former U.S. citizens will be required to obtain a visa to travel to the United States or show that they are eligible for admission pursuant to the terms of the visa waiver program. So when you renounce, now in the U.S., you need to show a visa once you renounce your citizenship. You can't just say, well, I'm indigenous to the land. You need to show a visa, show something that gives you a jurisdiction over here. Because the U.S. views these as their lands, unless you can show them that they're not, or that you're not subject to them. And just because you went stateless doesn't mean you're not subject to U.S. law. It just means you're not protected by their Constitution. If unable to qualify for a visa, the person could be permanently barred for entering the United States. If the Department of Homeland Security determines that the renunciation is motivated by tax avoidance purposes, the individual will be found inadmissible to the United States under Section 212A10E of the Immigration and Nationality Act as amended. Renunciation of U.S. citizenship may not prevent a foreign country from deporting that individual to the United States in some non-citizen status. So when you say you're renunciating your U.S. citizenship, beware. Just because you're not a U.S. citizen doesn't mean you won't be subject to U.S. law. It just means you won't have the protection of the U.S. Constitution. You gave up that right when you renunciated. Now let's look at the term, because this one gets thrown around as well, expatriation. And when you look up expatriation, once again, travel.state.gov, travel.state.gov. When you look up expatriation again, what you're going to see is that it says advice about possible loss of U.S. nationality and dual nationality. The Department of State is responsible for determining the nationality status of a person located outside the United States or in connection with the application for a U.S. passport while in the United States. Section 101A.22 of the Immigration and Nationality Act, INA, or the INA, states that the term national of the United States means A, citizen of the United States, or B, a person who, though not a citizen of the United States, owes permanent allegiance to the United States. Therefore, U.S. citizens are also U.S. nationals. Non-citizen nationality status refers only to individuals who were born either in American Samoa or on Swains Island to parents who are not citizens of the United States. So if you're not from American Samoa or Swains Island, then you're a U.S. citizen. Like that's basically what it says. Now, let's look at potentially expatriating acts. So these are acts that can get you expatriated. Section 349 of the INA, 8 U.S.C. 1481, as amended, states that U.S. nationals are subject to loss of nationality if they perform certain specified acts voluntarily and with the intention to relinquish U.S. nationality. Briefly stated, these acts include obtaining naturalization in a foreign state after the age of 18. If you're claiming to be under the Moroccan Empire, have you gone and gotten naturalized by Morocco? If you're claiming to be indigenous or autochthonous or an Indian, have you gone and gotten naturalized by any Indian tribe? No, you're a U.S. citizen. 2. Taking an oath, affirmation, or other formal declaration of allegiance to a foreign state or its political subdivisions after the age of 18. Have you done that? Have you gone to Morocco and taken an oath to Morocco? Or to an Indian tribe that's in a viable status? No? Then you're a U.S. citizen. Entering or serving in the armed forces of a foreign state, engaged in hostilities against the United States, or serving as a commissioned or non-commissioned officer in the armed forces of a foreign state. Section 349A(3) of the INA. Accepting. So have you done that? Are you serving in a foreign army that's at war? Are you a commissioned officer in a foreign nation? No? Then you're a U.S. citizen. 4. Accepting employment with a foreign government after the age of 18 if A. one has the nationality of that foreign state, or B. an oath or declaration of allegiance is required in accepting the position. Have any foreign governments employed you and required you to be a national of them, or required that you take an oath or declaration of allegiance? No, you're a U.S. citizen. Formally renounced U.S. nationality before a U.S. diplomatic or consular office outside the United States? No, you're a U.S. citizen. Formally renouncing U.S. nationality within the United States. The Department of Homeland Security is responsible for implementing this section of the law, and any inquiries should be directed to DHS, Section 349A6 of the INA. Have you gone to the Department of Homeland Security and renounced your U.S. citizenship? No? Then you're a U.S. citizen. And 7, conviction for any act of treason against the government of the United States, or for attempting by force to overthrow or bear arms against the government of the United States, Section 349A7. So, let me let that sit for a second. There's a process to renounce. Have you gone through any of these steps under U.S. law that you can walk around with any sort of standing to say you're not a new U.S. citizen? Now, no, 99.9% of you haven't, I bet. 99.9% of you haven't. Now let's look at the next section. Administrative presumption of intent to retain U.S. citizenship. As already noted, the actions listed above will result in the loss of U.S. nationality if performed voluntarily with the intention of relinquishing U.S. nationality. The Department has adopted an administrative presumption that U.S. nationals intend to retain United States nationality when they obtain naturalization in a foreign state, INA 349A1, declare their allegiance to a foreign state, INA 349A, serve as an officer in the armed forces of a foreign state not engaged in hostilities with the United States, INA 349A3, or accept non-policy level employment with a foreign government, INA 349A4. In accordance with the administrative presumption, when an individual commits one of the foregoing acts, that person will retain U.S. nationality unless he or she affirmatively, explicitly, and unequivocally asserts an intention to relinquish such nationality. So even if you did things like file and all that and run around saying you did, they still assume they have nationality over you until you go through the process of unequivocally, affirmatively, and explicitly letting them know you want to relinquish your nationality. So if you talk about you're an Indian, you're a Tachinis, you're a Moor, you're a sovereign, whatever it is, the title you give yourself, and then when they yoke you up, start talking about the U.S. Constitution, you're a U.S. citizen. You don't want to give that up. You're trying to invoke it. You're trying to talk to them about what they need to do under the U.S. Constitution. So you're not giving that up. And they're going to have an administrative presumption that you still want to keep your U.S. citizenship. So I will post these links in the bottom down there so you can see them. But it's very important to understand what you're saying and what you're doing. Now, this is the other element to keep in mind, because so many people talk about wanting to get out of things so that they don't have to pay taxes. Well, if you go to the IRS and look up expatriation tax, that's right. Even if you expatriate, you're going to get taxed because you were a former U.S. citizen. It says the expatriation tax provisions under Internal Revenue Code IRC sections 877 and 877A apply to U.S. citizens who have renounced their citizenship and long-term residence as defined in IRC 877E, who have ended their U.S. resident status for federal tax purposes. Different rules apply according to the date upon which you expatriated. So if they assume that you're expatriating because you want to get rid of taxes, which they'll find out about if you posted it on your Facebook ever, your IG ever, your TikTok ever. If you ever just made a general statement about not wanting to pay taxes, they're going to dig all that up. And they're going to say, oh, you're doing it because you don't want to pay taxes. Cool. If you expatriated after June 17, 2008, the IRC 877A expatriation rules apply to you if any of the following statements apply. Your average annual net income tax for the 5 years ending before the date of expatriation or termination of residency is more than a specified amount that is adjusted for inflation. $151,000 for 2012, $155,000 for 2013, $157,000 for 2014, and $160,000 for 2015. So I'm sure that most of us probably aren't going to have to worry about that. Probably not making that amount. But for those of us who are, who are trying to do things with money, if they find out that you were making that before you supposedly expatriated, you're going to get taxed. Secondly, your net worth is $2 million or more on the date of your expatriation or termination of residency. So if you got $2 million or more when you're expatriating, you're getting taxed. You fail to certify on Form 8854 that you have complied with all U.S. federal tax obligations for the 5 years preceding the date of your expatriation or terminacy of residency. So even if you expatriate but you haven't done taxes for the previous 5 years, then you're going to get taxed. And they say if any of these rules apply, you are a covered expatriate. A covered expatriate. Do you hear that language? A covered expatriate. A citizen will be treated as relinquishing his or her citizenship on the earliest of 4 possible dates. And they go into all of that. But you will be considered a covered expatriate for the purposes of being taxed by the U.S. government. A covered expatriate for the purposes of being taxed by the U.S. government. And you also may be a stateless citizen with no protections under the United States Constitution. Now I'm going to bring this back around full circle. Domestic terrorism. It's absolutely real. It's going to get very, very more focused on in these coming months and years and for the foreseeable future, because they're going to pass legislation about it. They're going to define it. They're going to talk about what it is, and then they're going to start applying it. And I'm sharing this because there was a particular instance where one of the tribal members from Meshipog got into an instance where a law enforcement agent, he was doing some things he shouldn't have been doing in the first place. But then started to say that he was going to commercially lien the law enforcement agent. And that was brought up as a felony charge. And you have to forgive me, I don't remember the exact charge. But it was something like threat to livelihood or something to that effect. But basically that he was making a commercial threat on his livelihood. A commercial threat on his livelihood. And it was a felony charge. So when we're saying that we're not going to pay taxes, you're not going to do all of these things, right? How are they going to interpret that in terms of domestic terrorism? If you're telling a police officer, I'll take your livelihood away from you. Basically, that's what you're saying when you tell them you're going to commercially lien their bond or all that. That's some strong language. That's commercial violence. Commercial violence. It's violent. You're threatening someone. Criminal. How does that get interpreted under domestic terrorism if you're telling police officers and law enforcement that you don't have to follow their laws, you don't have to pay their taxes, you're going to lien them? There's a whole bunch of people out there right now waking up to the fact that they may have some heritage that goes back to some Indian, um, some ancestry. And that's the final element that I want to kind of focus on as I close out my thoughts this evening. That most of us, when we talk about my aunt, my uncle, was an Indian, was a Choctaw, was a Narragansett, was a Shawnee, was a Catawba, was a Micmac, was an Iroquois. Take it out of the Indian context, was a Moor, was a Hebrew Israelite. When we talk all of that, what we're really talking about is our ancestry and our ancestors. We're not talking nationality. We're not talking citizenship. We're talking about our ancestors. And those are very different terms. You having certain ancestry doesn't mean translate over to your nationality and citizenship. Not necessarily. It can, but there are processes that you have to go through. And one of them is the process of repatriation, not expatriation, repatriation, going back to something. So, ancestor, and let's just look at what ancestor is. Under Black's law, an ancestor is one who has preceded another in direct line of descent. So when you make a claim that I'm indigenous, autochthonous, aboriginal, I'm a Cherokee, I'm a whatever it is, you have to show that by direct line of descent. It can't be a generic claim. And not only can it not be a generic claim, but just because you say it doesn't mean anything in law. You're just saying that you're a U.S. citizen who has some ancestry that goes to somewhere else. But you don't even know where that somewhere else is if you don't know your genealogy. The color of your skin, the curl of your hair, the size of your nose, the width of your lips, the color of your eyes have nothing to do with what your ancestors are or were necessarily. You could have ancestors that look nothing like you right now, but you're still related to them. That's still who your direct line of descent is. And if we take it a step further, another definition they have is a deceased person from whom another has inherited land. So if you're talking about land, then you have to point out who the exact deceased person is that you're inheriting these lands from. You can't just be like, oh, well, Lenape were over there and I'm a Lenape. From where? A Lenape from where? Where are your people from? And remember, your ancestry is only who your people are from. It has nothing to do with your nationality or citizenship. And that has to be with a foreign nation or state. Not something you just made up. Not something you just made up. Not a trust. You know what I'm saying? It all comes down to your bloodlines and who you descend from that gives you the rights that you get. And I want to keep in mind, American Indian, it's not a race. It's a political status. And we know this, if you can look up this case law, check it. Morton v. Mancari, 1974, where it was determined when they were looking at the issue of whether preferences for American Indians in hiring at the BIA, was a violation of the Constitution or discriminatory. And they held that no, it wasn't, because Indian is not a racial category. It's a political status. It's a political class. It has certain rights and privileges that have been afforded to it under the U.S. Constitution. So it has nothing to do with what you look like. It's about who you are, who your people are. And then, secondly, are you a part of some other viable political entity, like a tribe? In the U.S., the only sovereigns that the U.S. recognizes acknowledges exist are the states and the tribes. There's nothing else under U.S. law that the U.S. recognizes as a sovereign. The states and the tribes. Then it comes down to what status, what political status, what commercial relationship does that tribe have with the U.S.? A lot of them are federally recognized. Most of them don't have any at all because they're not commercially viable to have one. Then there's where FANA's moving at, and that is in a space of a separate commercial jurisdiction. But once again, that only comes from not only having bloodline, but bloodline to people that sign treaties and agreements with the European powers that now, through their ancestors and their ancestry, their direct, let me get the language right, direct line of descent from one who has preceded them. So direct line, not my people were, but directly I come from this person who signed this treaty, who had the rights to these lands that I'm supposed to inherit as his direct descendant. And then even that gets deeper, because then even if you are that descendant, who's had a closer relationship with their land? So if there's people there on that land that never left that land, even if you come from a direct line as well, your claim is subordinate to theirs because you weren't on those lands. You haven't been as involved with those lands. So it gets even deeper, but your ancestry is what is going to determine whether you have certain political rights in the U.S. And if you're not part of any separate body politic, if you're just an autochthonous, indigenous, aboriginal, whose grandparents were, you're a U.S. citizen and you're a U.S. national. And that's what you are. That's what you are. A U.S. citizen and a U.S. national. If you don't have rights to enforce treaties by having ancestors that signed them, then you can't really do anything outside of U.S. jurisdiction. It's assumed that you are a U.S. citizen. And it's assumed that that step you took was in violation of their laws, because you can't do that as a U.S. citizen. When you move in the capacity that FANA's been moving in, you establish a separate jurisdiction under U.S. law according to international principles that allows you to do those things that everyone's trying to do. It all comes down to your heritage, and it all comes together underneath the body politic, which is the tribe. And once again, Morton v. Mancari, American Indian is a political status, not a racial group or an ethnicity. So your ancestry does not change your nationality or citizenship in the U.S. unless you have voluntarily gone and renounced it or gotten expatriated, and then you become a stateless citizen because you're not a part of any tribe. You're not a part of any separate jurisdiction. You're just without protections under the U.S. Constitution. And we want to be clear at FANA. The issue is not that we are getting a raw deal from the law. The issue is that we don't understand the law and how to operate in it to protect ourselves. No one has to protect your rights under the law. You have to protect them. And if you need to go and hire someone because you don't understand the basics of how to do that, and they do a poor job for you and you don't know how to handle that, well, you get taken advantage of. That's the way the law is. And the other thing is that the law is not right or wrong. There's no morality or ethics in the law. Morality or ethics might be what was the impetus for a law, but they're not included in the law. It's just about what the law says and how it can be interpreted. So all of this is the wrong thing that happened to us, and that doesn't matter in the law. It doesn't matter in the law. What matters is, do you understand the law? Do you understand how it applies to you? And are you moving appropriately in it? And once again, Domestic terrorism is real, and it's getting realer. Black identity extremists is going to go right up underneath that. Commercial violence or some form of that sort of language you're going to see implemented as well. So if you're going and saying that you don't have to pay taxes and you're going to lean cops and you're not under their jurisdiction, you're going to be looked at as a domestic terrorist, commercial, on a commercial level. You're disrupting the livelihood of the entire U.S. economy. Right? You could be stirring up insurrection of others to do the same thing in an attempt to overthrow. You see where this can go? You see where a good lawyer, a good prosecutor could take that on you? It's wonderful, because that's the first step. It's wonderful that so many people are getting in touch with their genealogy, no matter where it comes from. Even if you're not an Indian, so what? Who are your people? What is their culture? It had to have been beautiful. It had to have been civilized. It had to have been strong. That's why they destroyed it. That's why colonization, that's why you're in the state that you're in right now, if you don't know it, because it was strong and beautiful, and they wanted to destroy it. So wherever you're from, honor that. But if you are indeed an Indian, then you need to know some things. And you need to stop complaining, and you need to stop trying to do things all on your own. That's an American mindset. That's the American way. If you're an Indian, your perspective should be coming from a tribal mindset anyway, and respecting a rank of order and a certain level of structure. Because in that manner, that's how you present yourself to other nations, because that's how they conduct themselves. You can't have an individual conversation with a nation. Your nation has to speak to them. And to that situation I spoke about earlier with the tribal member, when he came before the council, the instruction to him was, that's not how you conduct yourself. That's not how we conduct ourselves in this tribe. In the future, if you have an issue with law enforcement, you comply with them. Then you give us a call, and you let the tribe handle it, like any other nation would do. You would not see a French national over here getting arrested by cops here, screaming, I'm a French national. The French have treaties. You know, the French are older. The French had the first treaties. You can't know. They're going to go, and then they're going to reach out to their diplomatic office. They're going to reach out to their consulate, and they're going to ask their consulate to intercede on their behalf. That's how civilized people conduct themselves. They don't go yelling and screaming at law enforcement, throwing all types of laws at them. That's not how the quote-unquote civilized societies deal with each other. And that's not the way we should be dealing either. Domestic terrorism is real. So you need to know the difference between your ancestry, your nationality, and your citizenship. And understand, your citizenship is your citizenship. It's assumed that your citizenship is intact, and then they got jurisdiction over you. They'll tax you even when you expatriate, because you're under their jurisdiction. There's a specific process you have to go through, and to be quite honest, we wouldn't recommend you going through it. People from all over the world die trying to come to here to get the rights that are accorded here. It's not the system, it's the lack of understanding of how the legal system works. And once you get that understanding, and if you are who you say you are, then there's a path. But there's a path. It's not a make your own way sort of thing. There's a path, because that's how they structured it in this system, to make it as difficult as possible for anyone to do it. It's 2021. There's all sorts of madness going on in the world. And we suggest that in these times, instead of trying to stay abreast and in front of the world, we go back to the traditional ways. Don't try to stay ahead and speed up and keep ahead with it. Go back to the traditional ways of doing things, because those are the things that worked. The new ways haven't worked. For the past 400 years for us up here in the Northeast, when that Poconoke Treaty got signed, in 1621. This is the 400th year anniversary of it. Things haven't gone a good way by anyone who's adopted the mindset of we're going to do things our own way and not the way that they're supposed to be done. So, just some thoughts as always. Sorry for the ramblings. Yeah, your ancestry is not the same as your U.S. citizenship and nationality. And your U.S. citizenship and nationality is assumed over you unless you've gone through the specific process to renounce or expatriate. And if you haven't done that, you're putting yourself, especially under these domestic terrorist conversations that are going on, in a ripe situation to get a federal charge, potentially even for insurrection, trying to overthrow the U.S. government through commercial means. As always, Katapatush Wujia Chusuta, thank you for listening to me. And as we look forward to whatever this craziness of 2021 will bring after 2020, pray for blessings and guidance upon you all from Creator above. And we give you all prayers in all of your paths and journeys for a good way. Peace Ganache. See you soon.